Good morning and welcome to AM News Network presents The Morning Report with Rachel Baird and Ed Peruta. I'm Rachel Baird, he's Ed Peruta. We're here Monday through Thursdays from 7 to 7:30 a.m., Saturdays from 4 to 6 p.m., Summary Judgment Show where we're joined by Tyszkka. Transmitting live from our American News Media Center studio in Harwinton, Connecticut. We have been discussing the past couple days a concept called curtilage in Fourth Amendment constitutional law. Have we not, Ed?
We have.
And one question I had yesterday before we get to the real case at issue that we're going to discuss today is I live in a historic district. Okay? Connecticut, I guess a lot of states.
Set it up first.
How?
In order for your property around your house to be considered curtilage and subject to Fourth Amendment protections, it has to be somehow segregated and identified and protected by some types of perimeter objects.
Well, those of you who tuned in yesterday will know that a case out of the Second Circuit Court of Appeals, Harris v. O'Hare from 2014, sets forth the four factors in determining whether the property outside your home is curtilage. And these four factors are: 1, the proximity of the area claimed to be curtilage to the home. So your porch is probably curtilage, okay? Number 2, whether the area is included within the enclosure surrounding the home. A fence would help. Number 3, the nature of the uses to which the area is put. Do you have cookouts? Do you do those kind of things?
Ping pong tables, badminton,
toys all
swing
over the
set.
place.
Yeah.
Right. Number 4, the steps taken by the resident to protect the area from observation by people passing by. Think stockade fence. Okay, so with that in mind, I thought yesterday, I think we were in the car on the way to Middletown, I said, wait a second. I live in a historic district, and if I want to put up a fence around my house in Litchfield, I have to get the permission of the Historic District Commission. And if it doesn't match the tone of the, historic district or whatever, I get denied. And I have a feeling, that if I were to seek permission to put up an 8-foot stockade fence around my house, that I would be denied. But that would be the best way to signify my curtilage. And
to exercise your Fourth Amendment right to prevent people from coming onto your property.
So there is a real tension, I believe, between these standards set up by historic district commissions and your Fourth Amendment rights. So I thought about it, and then later in the night it struck me that there is a concept in the law, and this would probably apply, where when I moved into that house, it was part of the historic district. The rules were available at the town clerk's office, and so I knowingly submitted myself to this situation. I knowingly probably have waived many of my Fourth Amendment rights simply by choosing to live in that historic district. So the lesson here is, before you move into a place, consider what the rules are about what kind of enclosures you can have around your house, because it really could impact your constitutional rights someday. Agreed?
I understand your logic, but do I agree? No.
What do you think? I might win that fight if I wanted to put an 8-foot stockade fence completely around my house?
Well, I think that when you originally buy a house, you have no belief that the property is going to be violated. But you could have an event that all of a sudden says, whoa, I have to prevent this in the future. And then you say, I need to, because I've done some research that's in case law, not in the statute, it's not in the zoning, it's not in the historic district regulations. There is case law where the courts say you must have these items in place in order to protect your property and to be considered curtilage.
Well, point well taken. For example, if you move into a town and all of a sudden a police chief gets appointed, like Chief Riddick down in Waterbury, who seems to believe that when police officers come to your house, you need to just let them in and do whatever they want you to do, then that may alert you to the need to more prominently set forth what your
Let
Fourth
me
Amendment
give you a real
area is.
Let me give you a real situation. Person moves into the Litchfield Historic District, referenced as the borough, and
well, let me just make clear, I don't believe the whole borough is the historic district.
the historic district
Okay.
in Litchfield, and they have no concerns about people coming onto their property,
Well, it's not
whether
really
it's
people.
government or private individuals.
Ah, I see where you're going with this.
Okay?
Yeah.
And then all of a sudden, you find out that the state police at Troop L found one or more people on your property at 2 o'clock in the morning, okay, dressed in what looked like combat gear, carrying what looked like firearms, and turned out to be some type of facsimile airsoft guns playing paintball in the middle of the night on your property. All of a sudden, your antenna goes up and said, well, what if it wasn't young people in facsimile military, with facsimile firearms, and it was a real person or people with real firearms,
With different motivations.
with different motivations.
They're all real people.
With
but
different motivations. And you sit there and say, I have to prevent this in the future. I have to protect myself from this type of activity in the future. And if I have to, I'm going to put up an 8-foot stockade fence around my property, not to keep people in, but to keep people out.
And that really happened to me, and I forget how long ago it happened. And I
About 10 years.
Yeah, and I wrote letters about it. I was in my living room right next to the large picture window with 3 dogs. And apparently in the middle of the night, there were 3 or 4 youths right outside my window playing some sort of paintball camouflage thing. None of the dogs barked. Okay, that was number one. That was number one.
But they got picked up by the state police. They got caught by the state police.
Well, not my dogs, but the kids outside.
Yeah, people outside, because they must have been all over the neighborhood.
Okay, but the first weird thing is that none of the dogs barked, and then the second weird thing is Troop L never told me about it. I never knew all this had happened until a neighbor way down the street, who used to walk his collie up in front of my house all the time, said, gee, well, all the police were at your house. What do you think about that, those kids? And I'm like, this was like 3 days later. I'm like, what? I had no idea any of that had happened. That was the weird part.
But the question is, did they come on to curtilage or not?
And they didn't arrest those kids. And we're not going to mention names.
No.
We're not going to mention names, but they didn't arrest those kids. And I don't care. But this is what I do care about. They didn't arrest them because they were neighborhood kids. And I said to you that if they were kids from somewhere else,
Well,
they would have been in jail so fast for what they were doing.
There is, as we sit here today, a wave of car break-ins.
Well, I thought about that.
Around Connecticut, that basically they go to like apartment complexes where there's 200 cars they can go through. But it's still...
Okay, but this is my suspicion. Whenever you start seeing a lot of stories in the newspaper about something, all of a sudden all we see here in Connecticut is stories about cars being stolen. Is the stolen car crime task force trying to get more money? Are there really more cars being stolen? Maybe. I'd have to see the statistics, though, because when they want to push something, all of a sudden it is in the news all the time. This is what people like Deputy Chief Foley specialize in. We want to get this out to the news to just hammer it home to people that cars are being stolen for whatever reason they want to do it. And it may not be a bad reason. I'm not saying that. I'm just saying when all of a sudden you start seeing all these stories about something, you got to ask yourself, What is going on? Does somebody want me to focus on this and think that something needs to be done immediately? I mean, cars have always been stolen. So that's what I think about it first. And when you yawn, it doesn't bother me a bit. Let's get back to the Fourth Amendment, because we were reading a case yesterday in our ongoing research project for Joe Kaminsky's brief that is now due on Friday. I hope. I asked for 3 more days. I won't presume I'll get it, but let's keep our fingers crossed till Friday. Kentucky v. King. It's a 2011 United States Supreme Court case. Let me set it up for you. You can interrupt anywhere you want. Lexington, Kentucky. There's an undercover officer outside an apartment complex. He's watching a controlled buy. What's a controlled buy?
Undercover officer is purchasing narcotics from a street vendor of narcotics, and that's a controlled buy.
Yeah, I think it's more of, it's an undercover officer watching some sort of reliable and confidential informant purchase the drugs, right?
Well, okay.
Yeah, I think that's how it usually happens.
You know the buyer.
Yeah, and so the undercover officer will maybe mark the money, give it to the confidential informant. Confidential informant hands the marked money over to buy the drugs, gets the drugs. When you catch the guy who sold the drugs, he's got the marked money. Bam! Another conviction, another guy in jail. So there you go. So this is what they were doing in Lexington, Kentucky, the officer. And so once he saw the controlled buy, put out on the radio, 2 uniformed cops come, maybe more, I think. Officer Cobb comes. He's running down the breezeway of the apartment complex. But he doesn't hear the undercover officer say, apartment on the right at the end, apartment on the right at the end. So he gets to the end, he smells marijuana, seems to be coming from the left. So he knocks hard on the left, and nobody answers, but he hears a lot of movement inside, which in his training and experience, he can differentiate what that movement means. Does it mean that people are scared out of their minds because a cop's knocking on the door? Or does it mean they're destroying evidence? Well,
or are they having wild sex?
To his trained mind, it meant they were destroying evidence, which gave him the exception to the Fourth Amendment of exigent circumstances to enter that apartment so that the evidence would not be destroyed. You follow me?
I do.
Well, the apartment he went into was Hollis King's apartment. His girlfriend was there, and another visitor was there smoking marijuana. It appears to be an apartment complex where maybe more than one unit engages in the use of illegal drugs. It's not just one unit. It could be more.
There are those kind of apartment complexes around.
Somehow they find out, they do a protective sweep of the apartment. They find cocaine, paraphernalia, cash, and Hollis King gets arrested. Eventually they go in the right-hand apartment where they should have gone in the first place. But who cares about that? Because the case is called Kentucky v. Hollis King, because Hollis King was arrested, motion to suppress denied due to exigent circumstances, sentenced to 11 years in jail, and affirmed by the Kentucky Appellate Court. And it was appealed to the United States Supreme Court, and we learned about this yesterday. It was appealed to the United States Supreme Court because Hollis King's attorney said, there may be an exception to the Fourth Amendment for exigent circumstances to prevent evidence from being destroyed, but there's an exception to the exception. And the exception to the exception applied here because over the years, lower courts, not the United States Supreme Court, have developed an exception to the exigent circumstances rule, which is the so-called police-created exigency doctrine. Describe that, Ed. I'm going to test you from our conversation at lunch yesterday.
Well, let me put it this way. If the police fire a bullet through a window and hit a person on the inside of the house, they've created the exigent circumstance of having to go into the house to treat the person they shot.
Yeah, because we were trying to think of examples of this, a police-created exigency circumstance. It's not that easy. But in Hollis King's case, his attorney argued that by knocking on the door of Hollis King's apartment and announcing their presence, the police caused the occupants to attempt to destroy evidence, and their attempt to destroy evidence is what allowed the police to go into the apartment. And according to Mr. King's attorney, that's not right.
So here's what you have to do. You have to start at the arrest and then step back in time to the finding of the narcotics and paraphernalia, and then step back to the safety sweep of the apartment, and then step back to the marijuana scene, and step back. You see, you have to keep stepping back, okay? And when you finally get to the knocking on the door, they say, well, had you not knocked on the door, they wouldn't have made any noise on the inside, and there would have been no reason to go into that apartment. But you knocked on the door. You know, I mean, I'll tell you, I believe that there's probably a lot of people that if there's a hard knock at your door and somebody's, this is the police, there's going to be some activity in the house.
But you know.
No. Whoa, stop.
Yeah.
Stop. And there's a good way to explain this.
Okay, good.
When I'm home alone, watching TV, in my recliner, there's times that I'm sitting in my underwear. There's a knock at the door. Holy shit. So I run to the bedroom to put on some clothes to answer the door. If one heard my footsteps going across the floor of my condo, is that an exigent circumstance to come in and search? Thinking that I must be doing something wrong based on training and experience? Why would anybody run from a door when a policeman announces himself? Fuck, I do it when a neighbor knocks for milk or sugar if I'm sitting there in my underwear.
That's a really good point. And you know that the Supreme Court could not have, based on the facts in this case, ruled in favor of King. Because you just think about it. That argument just can't fly. That the police knocked on my door and that caused me to destroy evidence. So therefore, they created the exigency and they can't come in. You know that's not going to work, right? You can see that. You can see that a mile away. But you know the issue made it to the Supreme Court. So good for Hollis King's attorney, right? Because it's an interesting issue. You know, it's a good try. But listen to what the court said. Okay. The Supreme Court said basically what I just said. We can't have that result. We can't let defendants argue that. So they said lower courts have held that the police created exigency doctrine requires more than simple causation. So right now, police knock on the door, you go to destroy the evidence. That's simple causation. But the courts haven't agreed on what constitutes above and beyond simple causation. We all agree that knock on the door, destroy, not enough. What else would be needed, though, for somebody to argue that it was a police-created exigency? And that's what this case answers in 2011. It goes through all the different tests. Okay, and they said the answer to the question before us is that the exigent circumstances rule justifies a warrantless search when the conduct of the police preceding the exigency is reasonable. So if it was reasonable for the police to knock on the door and that caused you to destroy evidence, then there's no police-created exigency. But in your case, if a police officer fires a gun through your window and shoots you and then claims that there's an exigency because he's got to go in and save your life, that's not reasonable. So that would not fly. Does that make sense?
Yeah.
This isn't that hard after all. I think we were,
Well, let me.
When we were discussing this yesterday, we were kind of.
You know, I mean, there's using that shooting into the house is can be. There's a lot of variables to that. A lot of variables.
So the Supreme Court ends up concluding that the exigency did justify the warrantless search of the apartment. Now, what if the officers just went up and down the breezeway of that apartment and knocked on all the doors and heard rustling from the inside? Because they say the marijuana smoke seemed to be coming from the left, but I got to tell you, if you're in a hallway like that, it could be coming from anywhere. So what if they just went up and down the doors and knocked and heard people moving inside, and that was their reason to go through the door?
Based on their training and experience.
Based on their training and experience. I guess you have to have a reason to knock to begin with. You have to have a reason. So maybe, now in this case, Justice Ginsburg dissented. It's funny because a lot of the times we find ourselves, especially on gun issues, in the opposite corner from Justice Ginsburg, Justice Sotomayor, especially. But in Fourth Amendment issues, sometimes we find ourselves on their page. You know, she actually dissented in this case, and she said, "The court today arms the police with a way routinely to dishonor the Fourth Amendment's warrant requirement in drug cases. In lieu of presenting their evidence to a neutral magistrate, police officers may now knock, listen, then break down the door, never mind that they had ample time to obtain a warrant. I dissent from the court's reduction of the Fourth Amendment's force."
That's almost as powerful as Thomas.
I was going to say that. I was going to say it reminds me of Thomas's dissent in your case, Peruta v. California.
Well, yeah.
The question presented, may police, who could pause to gain the approval of a neutral magistrate, dispense with the need to get a warrant by themselves, creating exigent circumstances? I would answer no, as did the Kentucky Supreme Court. The urgency must exist, I would rule, when the police come on the scene, not subsequent to their arrival, prompted by their own conduct.
Well, okay, so let me say this.
I love what she's saying, but in practicality, that's not going to work with
but
drugs.
Let me just say something. If, and I see this I see what Ginsburg is saying. So from now on, from this day forward, a police officer will learn somehow, he'll acquire the knowledge of this case, and he'll say, we can go into any goddamn apartment we want. All we got to do is say we heard noise.
And that's what we said before we even read Ginsburg.
Right,
We were
right.
talking
In
about
other
that.
words, I've said this repeatedly, that if a police officer was to follow any vehicle, even another police vehicle or the chief of police, follow him for one day, an 8-hour day. Just let the chief drive and you drive behind him. You will see him commit a dozen traffic violations, justifying the stop of that vehicle. Now, let me finish. I believe that, the marker light is out at night, a tail light is out, you fail to signal, all of these things, they don't run around telling you to get them fixed during the day, because it's good to have a car with a brake light out or a directional out, because when you stop him and not call it in or record it, and you find out that there's drugs in the car, then you go back to your cruiser, you call it in, and you say, I pulled him over, I had probable cause because the brake light was out.
Okay, and that's an interesting argument in light of the argument that you were making about racial profiling a week or two ago, where, a town like Wethersfield or Berlin that has main highways in and out of, Hartford may have more.
I have to say something because I want to get this out.
Yeah.
My admiration for Chief of Police James Citran. Are you aware of what happened yesterday? Okay.
Okay, go ahead.
On Facebook, there was a shoplifting on the Silestine Highway.
Mm-hmm.
and with a dash cam rolling, the chief of police in his fucking gray suit got out and went to apprehend the suspect on the sidewalk. The suspect began to resist, and the suspect and Chief Citran went to the ground. And Chief Citran handcuffed that son of a bitch when the new 2 supporting units came up, and it's on Facebook today, and Jimmy put up there, I still have the ability to take him down. So my admiration to Chief James Citran, because he is still a sworn police officer, and when he was there, he didn't wait for one of his guys to do it. He did it himself. He's leading by example. But it was on all of the websites. The news media got it. You know, Chief of Wethersfield PD tackles a shoplifting suspect.
Thanks. So back
to I had to get that out.
The racial profiling issue that we talked about a couple weeks ago was that the statistics may be skewed on, you know, how many people of color the police stop as opposed to white people. For example, if your town has 80% white people, but the percentage of people you're stopping of color is 50%, then it seems to be skewed, right? And we said, well, they don't take into all the variables, perhaps, of certain towns have direct routes in and out of the city and this and that. But your argument that the police wait and don't stop people with broken headlights or whatever because they want the ability to stop those cars when they suspect other things might be going on. I'm wondering how that concept or that practice dovetails with what you're saying and maybe does support that there's profiling.
Well, let me give you another one. I'm a police officer and I have a warrant for your arrest, for the arrest of Rachel M. Baird for shoplifting.
And I don't have my stockade fence up.
But I know that you smoke marijuana. I know you snort heroin. I mean, snort cocaine or heroin. I know this. So I have a warrant, and I put it in a file at the office. I don't serve it right away. I don't announce it right away. I fucking wait. Now I know that warrant is in the file. Now I watch you. And I wait until you have the marijuana or have the cocaine, or I suspect that. Now I pull you over and I say, I have a warrant for your arrest. Now I do a search and I find the drugs.
See, I don't really have a problem with that.
What I'm saying is there should be a fucking list where you can check every outstanding arrest warrant in the state of Connecticut, and you can see if anybody in your neighborhood has an arrest warrant.
Yeah, I don't know why they don't do that. They actually put up...
That's your ass.
They actually put up violation of probation warrants and failure to appear warrants, I think. So why can't they put up the other ones?
Publish in a list all outstanding arrest warrants that are to be filed. Some people wait 14 years to serve them.
Okay, so going on with...
We're out of time.
What? No! Oh, darn.
We're back. You're back with Chris tomorrow.
Chris Janko tomorrow. We'll hear what's been up in his life and in the community. Everybody have a good Wednesday. See you tomorrow. Not Ed.
Adios.
Bye.
I'm sorry.